I'm Elizabeth, and I am going to be speaking today with my property litigation expert, Michael Large.
Hello, everyone.
Just to briefly touch upon DR Solicitors, as I'm sure you've heard of all of us before from joining this webinar, we are a one-stop shop, you would say, for all matters related to primary care. We have been advising for over 20 years to general practices, primary care networks, numerous GP federations and local medical committees. We are the largest and most experienced team of solicitors in the country who are focused primarily on primary care. We've advised over 3,000 general practices and over 250 primary care networks. Our core expertise is a deep understanding of all the NHS and healthcare regulation, and we apply these to all other aspects of law, including commercial, regulatory, property, disputes, employment, corporate and partnerships, and more. So I am Elizabeth. I am the legal director at DR Solicitors. By profession, I am a commercial property solicitor with over 10 years of experience, and I'm now a specialist in primary care. And I'll hand over to my colleague, Michael Large, to introduce himself.
Hello, everyone. I'm also at DR. I'm a specialist property litigator. I've been dealing with commercial property litigation for just over 20 years, a lot of it involving commercial service charges, and indeed I do lecture for other organisations who are on the slide about numerous things, including commercial service charges.
Thank you, Michael. So we're all here today to talk about service charge issues, and this is related not just to NHSPS, but can also be related to CHP and any private landlords that you have as well, because we're talking about general principles here. So why should you be concerned about service charge issues? First and foremost is financial and accounting issues. We are seeing that lots of our clients are finding it very difficult now to have these issues on their balance sheets. As partners come and go, this liability becomes a larger share of their capital accounts. And we're seeing retired partners asking why they should leave their capital behind for a liability that might not come to fruition, or they don't believe is really owed, or they don't know how much is owed. So as you can see, this creates issues with outgoing partners and quantifying their liability and how this is sorted. It also becomes problematic with attracting incoming partners and basically having talent come through your business. Also causes issues with practice mergers in terms of one practice having a service charge liability, for example, and another practice not having any service charge liability. Obviously, the practice which doesn't have such liability doesn't want to take on the liability of the other practice and wants to be ring-fenced from it. And then these issues are also causing stumbling blocks when it comes to negotiating a new lease or lease renewal with not just NHSPS, but CHP or possibly your private landlords. But most importantly, when we'll talk about this later, when it comes to service charge issues and negotiating a new lease, we see these issues as being two sides of a coin, trying to sort one and also the other at the same time. I just wanted to touch briefly upon deals and outcomes that we have achieved for our clients over the years. I've selected a few that you can see very easily as to what we've achieved for our clients. This is quite a broad spectrum. So you can see that we're talking about large amounts of money here. And we're talking about where we have either managed to wipe them off the balance sheet, but having them paid at a considerably reduced level going forward, or we are having thousands of pounds of service charge liability settled at lower amounts, and other amounts, smaller amounts, wiped off entirely. And all of this really depends on strategy, the advice that you get, and holding really firm in your approach going forwards. So this is just a snapshot of the outcomes that we've achieved for our clients over the years. We can always come back to this slide later. So this is the agenda that we will be talking about today. We'll stop for questions at the end, and we will I'll now hand over to Michael, who will be talking about service charge terms in the lease, if there is one.
Thank you, Elizabeth. The basic starting point for any service charge, a collection of it, how much is due, all that sort of thing, is going to be the terms of the lease. And as I put there on the slide, if there is one, have you got something to work with? Is there a contract to start from basis? And I will talk a little bit about how that works because it's useful. A lot of people will have written leases, but quite a few won't. And one of the major problems, which we know from litigation and from dealing in this area, is that major problem with many of these disputes tends to be a lack of contractual clauses. What do you do if there aren't any contractual clauses? How do you look at that? And we'll talk in general terms about how that works in practice and how the law deals with it, more importantly. So the provisions of basic service charge clause, if there is one, there'll be a definition of services for which a charge can be made by a landlord, and there might be loads and loads of that. There might be a great long list of cleaning and all manner of other things in there. Typically is quite a long list. And then usually at the end of the great big long list, there might be what we call, as lawyers, a sweeper clause. It might say, here is your list of 200 things, and 201 is any other stuff that I decide to provide you. So that's a sweeper clause. And the tenant's obligation is to contribute to that cost, including, and it should include a method of calculation. Yes, you have to contribute. How much is going to be always the crucial question. Yeah, I've got to pay, but how much? And there should be some kind of contractual procedure and timetable for certifying and invoicing those charges. How that is meant to work in commercial service charge arena is that it will say something like the service charge year is from the end of March, start of April, and in maybe December, you'll get some kind of interim invoice, estimated invoice, and then at the end of March, or whenever, or maybe the start of April, you'll get your final invoice, your balancing one, so you either get some money back or you top it up, depending on how things have gone. And there should in there be some kind of certification procedure. That's what you'd expect in a normal commercial lease, which might say something like service charge accounts to be audited by the landlord's accountant and then certified by the surveyor or something like that. And that's all very well. That's all great, me saying there should be all this stuff. What if there isn't? That becomes problematic. It's difficult enough often when you've got all these things, all these rules to work from. It's even more difficult if you don't. But that's our basic kind of parameters, what we're looking at.
So if we don't have a service, you don't have a lease in place, we are going to move on to what documents can rely on and what the case law says. So we'll move on to the RICS professional statement, and I'll move across to Michael to explain what that is.
The RICS professional statement is a little bit of a sideways step. If you haven't got anything to work with, what have you got? Well, here's something that there is. We can suggest there are various RICS professional statements, and there's a lease code which contain requirements, core principles, and best practice. The RSCS, the Royal Institution of Chartered Surveyors, they are the surveying profession. This is their governing body. Probably everybody knows that. Apologies. And they've put these best practice guidelines out there. They're not the law, I hasten to add. They're not binding, although they may be binding on surveyors who are members of the RICS, because if they ride roughshod over those rules, they might get in trouble with their regulator. But they have some kind of value, because if we got nothing, we need to have something to cling on to say, well, how should this be done? What should it be? And it contains, there's reams and reams and reams of this stuff, but it does contain various useful recommendations. For instance, to pick a few here, you shouldn't calculate by reference to rateable values. You should do it more often by the floor spaces that the tenants are using, for instance. An apportionment as to charges should be demonstrably fair and reasonable. If you're using 10% of the space, but you're being asked to pay 90% of the charges, then you can argue, well, hang on a minute, you've breached the guidelines there, landlord. It requires tenants to be given the opportunity to question and dispute the service charge, and it also contains provisions aimed at ensuring service charges provide value for money. Now, these are evidence. They are not binding unless the lease says they are. You might not even have a lease, in which case they're certainly not going to say they're binding. But they are there. There's something to argue about. If you've got nothing else, then you've got this. You could say, well, hang on a minute, it's not fair. It doesn't follow the guidelines, and so on and so forth. So we take a bit of a sideways step to say, if you don't have a lease, or if you do have a lease, here's something you can look at. Here's something you could use, not exactly to hide behind, but as a basis of making your arguments. So if we can move on to the next slide, that'd be great. Service charges and special rules of interpretation. This is a slightly funny one. Do they have special rules? The short answer to that is they're not supposed to, and that's the case of Arnold and Britton. But in fact, there are some special rules. There are some special legal rules you can look at and use in defence potentially, but there's not meant to be a particular special rules for these. They're supposed to be looked at like any other contract. Residential service charges, as many of you may know, have enormous amounts of regulation. There's a great big book, which is the site, which would be really useful for stopping your door, or if you dropped it off a multi-story car park, it probably kills someone. Enormous book with residential service charge rules. Nothing like that here. It's all much more opened up for grabs. There aren't loads and loads of statutes in Parliament. There aren't tons and tons of things like that. There's nothing. There are some cases and a couple of statutes that apply just anyway. A couple of cases we do have are Fleur Daniel, which says if you've got one of these sweeper clauses that I mentioned, if the landlord says, well, look, I'm claiming, it doesn't say in your main list, but I'm claiming it under the sweeper clause, then the court will look at those very restrictively and argue and might be able to get them excluded. Also, if you've only got a couple of years left on your lease, then it's unlikely that it's more likely that the court will restrict what you've got to pay for. I know a lot of you out there are just going to be in your building forever, so it might not be that much use to you, but there are people who move. People do, of course, do that. In that case, the tenant had 6 months left on the lease, and the landlord could either repair the whole thing at vast expense, or patch and bill the tenant, or patch it up at not very big expense. And what did they do? Of course, they repaired the whole thing at vast expense, and the court said, no, you can only get the costs of the patch repairs. So there's a few bits and pieces like that that are quite useful. If another case that's useful, Russell and Layman, not useful to us, useful to landlords, but you need to be aware of it. Even if you're obliged to pay for services, doesn't necessarily mean the landlord has to provide them. So watch out for that. If the landlord provides services, then you're going to have to pay for them, or how much is the next question, but you'll have to pay for them. But if they aren't obliged to provide them, then they're not, and you can't demand it. And another one we got here, Craighead and Islington, repairs are usually chargeable, but not improvements. So if the lift's broken, needs fixing, yes. If the landlord wants to put in an entirely new lift, probably not. So those are our kind of special rules. Another set of rules, they're not really special to leases, are dispute resolution clauses. These are well worth knowing about. They're not particularly well, they're not unique to service charges, but they may be useful. Your lease should set out, if you got one, how to deal with disputes. And that might say they're referred to an expert, they're referred to mediation. If you're really unlucky, they might say something like it's referred to the landlord surveyor, who is the final decision maker on the authority. Those on the thing, those do exist. That's not great if you got that. So there should be something in there, and those are quite common with service charges. It is quite common to have something in there. There is a difference between expert, mediation, and arbitration, which we haven't mentioned on that first point. Experts might be appointed by the parties just anyway, or if you can't agree, by the president of an appropriate body. I don't think the BMA does this anymore, but the RICS certainly do. You can agree, and the onus here is on the word agree, if there is no such clause, and if there is no lease, there will be no such clause. You and the landlord can get around the table and say, we'll agree to send it to an expert, Mr. or Mrs. or Ms. so-and-so, and he, she, whatever, will decide this after hearing our arguments. You can absolutely do that, but it takes two to tango. If the lease doesn't say you do that, you've got to agree it. The landlord's starting point on dispute resolution is going to be certified or audited service charge statements. They may have some kind of clause in the lease, if there is a lease, sorry to keep harping on about that, that says it's binding on the tenant, except for manifest error, but that's going to be where the landlord is or should be starting from. Tenant will want to have the right to dispute that. Hopefully your lease provides that. We know that the RICS code says you should, so do check that the statement has been properly audited if there are any auditing requirements, and not just signed off by anybody, because it may be very important that it's signed off by the right person. If you're going to go to court or mediation, independent expert, arbitration, do think about that very carefully, because that will take you deal with it in different ways and have different costs associated with it. So that is going to take some careful thought. It's a bit difficult to get too involved in that at this present time, but what I could say is that, what I certainly can say is, if you're going to court, it's out in public. Everyone's going to see it. If you want to keep it secret, confidential, then mediation, expert, arbitration is where you want to be going, because whatever else, it's just going to happen behind closed doors, for good or ill.
And just to add that we at DR, we've never actually had one of these service charge matters go all the way to court, not just for costs reasons, but for various other reasons. There's always the ability to settle. And we'll move on to the Valley View case, which is the BMA case, which I'm sure you're all aware of. Yeah. I'll leave Michael just to briefly go over the facts of the case and then draw out the main messages from the judgment.
Thanks, Elizabeth. I probably would think that the GV's practices in Valley View, bless them, wish they hadn't gone to court, unfortunately, for them. We're probably all very familiar with this. There were 5 test cases, all heard together. Some of them had written leases and some didn't. So there was a load of argument about what happened to those who didn't have written leases and so on and so forth, which I don't need to go in through here. One of the main points we take from the judgment: each dispute turns on its facts. Where there's no written agreement, if you just, or maybe a predecessor practice has gone in and just done the work for umpteen years and there's no unpaid rent, then the court looks at the conduct of the parties and it may imply terms where necessary. It's not supposed to make them up. It's supposed to say, well, that's what you were doing, so there is an implied term. That's what it is. As an ordinary landlord, NHSPS has the right to recover a reasonable service charge. One of the arguments that was run in Valley View was that there's no written lease, so you can't get service charges. There's no contract. Tough. The court absolutely rejected that, so that's not going to fly. It has the right, and that will apply to any landlord in this area, whether it's NHSPS or someone else, to recover a reasonable service charge for services it delivers. What does reasonable mean? Of course, that's another thing. But anyway, if you're saying that you should receive discounted or even free services from your landlord, then you need some pretty solid evidence of that. It is possible you might have reached an agreement that in return for, I don't know, a higher rent or something, you'll get free services. It's possible. I've not come across one, but it's possible. You may, what we commonly come across more is some kind of agreement to say these should be discounted. The court's not saying you won't get that, but you need pretty solid evidence to show that that's happened. And in the Valley View case, the real question that everyone's probably interested in, how much, they end up settling, because at the end of, when the dust settled on that, the court said, yeah, you got to pay. How much you got to pay? That's next. And that never happened in court, because the parties sat in a room somewhere and, I don't know, no doubt either shouted at each other or had a very nice conversation over a cup of tea or whatever they did. But they, depending on who was in there, but I'm sure it was the latter, and they got to some kind of mutually acceptable solution, and it went away as far as the courts are concerned.
Thank you, Michael. So just to move on to our next steps to protect your position. Number one, we would always say, is to not ignore the problem. If you get correspondence from solicitors acting for your landlord, whoever it may be, please don't ignore it and stuff it away in a cabinet somewhere. Please use the opportunity to establish your liability and to consider whether or not you have a lease in place, dig it out from wherever it is, and what you have been paying historically. Which obviously leads on to the second point is, has there been any agreement as to what services are to be provided? And as we've seen from previous slides, you should be paying a reasonable amount for the services that you receive, not just from NHSPS, but from CHP or your private landlord, unless you can provide solid evidence of an agreement to pay less. And also to keep in mind that you do have the ability to challenge the costs that you are being demanded. You can request evidence of the costs being charged and a breakdown. And so it's really important to keep safe records of all the charges that you have been demanded and also what you have paid over the years. The more evidence that you have collected over the years, the more paperwork that you have, the easier it is for us as your solicitors to advise you and to go through and see what's happened historically. As Michael has touched on, consider what defences that you may be open to you. For example, using the test of reasonableness, has what you have been charged been reasonable? Has what you've been charged actually been a repair, or have some of these been improvements? As you can see from the previous slides and what we've talked about, landlords can charge for repairs, but they can't charge for improvements. So there's a distinction between that. So always to consider in terms of what you've been charged, whether it's a repair or an improvement. There's also the RICS guidance, which whilst it's not legally binding, is also is helpful and is the basis on which you can have a look at what it says in there and how it can help your position. And then we can also consider things like alternative dispute resolution, like expert determination and mediation. Obviously, there are costs involved in that, but with these matters, they are very loath to go to court and very unlikely to go to court as well. So getting legal advice on what defences you may have is really important as well. Also, your partnership deeds need to be really clear about what happens when partners leave and when partners join. The last thing that you want is for there to be ambiguity and uncertainty about what partners who are leaving are responsible for, and also partners who are joining, they want to know what the situation is. So when partners leave and join, the lease needs to be assigned to reflect changes in your partnership. There will need to be indemnities from outgoing partners, as well as any provisions about service charge retention and how much money may be left behind in a retention fund. So the partnership deed is really crucial in all of this and needs to be really, really clear. If there's any issues with this, it can cause all manner of headaches. So we can always advise on that as well. The last 2 points are firstly negotiating a new lease with NHSPS or CHP or whoever your landlord is. You can use your leveraging position to get a new lease agreed. And we are finding that this is, as I said, two sides of the coin, sorting out your service charge issues and again getting a lease agreed at the same time. What you don't want is to sort out your service charge issues but then not have a lease agreed, and then for this service charge problem just to become a recurring problem going forwards, which is the last thing that you want. And then lastly is to always seek legal advice before you start negotiating with NHSPS or CHP or your private landlord. If you're called into a meeting and you don't know what the meeting is about, then you have the right to not go to that meeting. There can be various tactics that are used to bring you to the negotiating table, but in order to know the best route to take and the strategy to take going forwards, you need to get specialist legal advice, and this is what we can provide for you to give you a steer as to what your options are, our recommendations, and what the strategy is going forwards, because there always needs to be a strategy with these sorts of negotiations. Just bunging numbers out from nowhere without any evidence, and then also negotiating on numbers without knowing what your position is not it's not something that we recommend. So always seek specialist legal advice and to get a clear strategy going forwards.